18-0861. Each side is allocated 20 minutes for oral argument. Appellant, if you wish to reserve a portion of that time, you're free to do so, although you need to keep track of your own time. I would ask those in attendance to make sure that their cell phones are off so the presentations are not interrupted and so you can avoid embarrassment. We have reviewed the briefs and the record. We've conferenced the case. We'd encourage you to keep that in mind as you present oral argument to us today. Please also, as you approach the podium, tell us your name and the party that you represent for future reference as we post our proceedings today. With that, Mr. Wolenchek.
I would like to reserve some time, Your Honor, and for the record, I'm Dennis Wolenchek, representing Addison John Reyna. Morning. I know you've read the briefs. Let me just try to hit a couple of points that I think are important in terms of whether there was substantial evidence to support the verdict and the judge's decision to not grant the new trial.
Is that the standard for us?
I'm sorry?
Is that the standard for us?
I think so. I think that both parties agreed. I just reread the state's brief, and I think that's... Am I mistaken?
Well, I was thought it was whether it was contrary to the weight of the evidence.
I think that may be more the civil standard. I think both parties briefed it, but and not to spend a lot of time on that because I was just listening to the U.S. Supreme Court argument on C-SPAN coming over here. They were debating for about 10 minutes the distinction between the but-for test and some other standard. And in the end, I think they all agreed it really didn't matter much. I don't want to really get into that. I think either way, let me just end that with this. Either way, clearly the verdict was contrary to the evidence and also against the substantial weight of the evidence, which has to support the court in its new trial determination. And let me just tick off, Your Honor, some of these points. And basically, I can probably summarize it by saying this. Seems to me, this may be a bold statement, but it seems to me that going back to the days when I started out, eyewitness identification was pretty much all you had. Things have changed in the world a lot, and I think the court system in all candor has to keep up with that. Today we have scientific evidence that's far more reliable. In this case, the only dispute I have with the state's rendition is that it's not a situation here with the DNA evidence, which I think is critical, given the factual scenario that he supposedly had his bare arm slammed in the door jamb. That evidence is not inconclusive. That evidence was conclusive, that there was a third party's DNA. Now, you could always make the argument that he left no DNA, I suppose, but clearly under the circumstances, it appears that he more than likely, to a certainty, did leave DNA evidence when she slammed the door in his arm, given that there was other DNA evidence of her and her boyfriend when they didn't get their arms slammed, and a third party.
So are you saying that the lack of DNA evidence is dispositive? That because there is no DNA evidence?
No, there was DNA evidence. That's my point. So, excuse me for interrupting. Sure. But there was DNA evidence. It just wasn't him. He was excluded from the DNA evidence. And that's very important, which is distinguishable from what I think they're saying. It's not what you just said, Your Honor. There was DNA evidence of a third party. And when you compare that...
I thought it was mixed.
I read it again. I don't try to substitute my reading for yours, but I believe that the evidence was conclusive from the state's witnesses, including no fingerprints, by the way, to throw that in. But I wouldn't even say that was, all that conclusive, although it's certainly evidence that should be considered. But when you do have DNA evidence of the very area swabbed where she claims his arm was pinched, if you will, or slammed, when he wasn't wearing a shirt, I think when he's excluded by this, these are the state's witnesses, not the defense witnesses. And by the way, all the state's experts basically, in my opinion, excluded him and absolved him in terms of the computer, the cell phone records, and everything else. And think about this just for a second. You're talking about a guy who's waiting for his father to pick him up. and he runs away after at 4:11, changes clothes into this outfit because his father had seen him earlier in the day and later in the day with a different outfit. Changes clothes, runs over, knows the garage door is magically open, which is kind of odd, and then supposedly goes in the home, doesn't say a word, brandishes a weapon, has tattoos all over his body, basically, including the hand that was holding the knife. She doesn't describe that. She describes a 5'9" person. He's 6'2", different beard, etc. But I think the most important part of that is, quite honestly, is in the analysis of the DNA, is that we have this Reyna de la Mora, and his testimony to me is critical in light of the DNA. He actually, because the only thing they had was this red suspender thing, tan pants and white shirt, and her description, however, she'd seen him before many times, and you have a tainted lineup identification.
Well, you say that it was tainted with our finding that
The only person in the six-pack that was shown to him,
so
that was shown to her, excuse me.
So the ID
Was tainted.
evidence was excluded then because it was tainted.
Absolutely, and when you consider,
So all of her ID evidence didn't come in.
well, if this were retried, I'd certainly argue that.
But so the ID evidence did come in then.
The ID came in, of course, yes.
So if it is like this, he said, she said, how can we say?
Well, I don't think it's a he said, she. See, that's what Judge Como said, and I don't think this is in any way, shape, or form. He said, she said, when you have DNA evidence of an area that should be the assailant, when you have Reyna de la Mora saying within 15 minutes of the police questioning him, he identified someone with the same clothing and the same kind of general description, but it wasn't, he said. He excluded my client. He excluded him, not saying, as opposed to what they said, that it was inconclusive or anything. He excluded him, said, I cannot identify that as being the person.
Well, doesn't that conversation also help? I mean, without regard to whether it was the defendant or not that engaged with
Absolutely.
the witness, the casual nature of that conversation tends to disprove the fact that he walked with purpose.
Absolutely.
The 2/10 of a mile around the corner.
Or that he's running back to his father who's picking him up around 4:30, and he's having this conversation with the guy, something about his car or something, I don't know. But it's absurd.
But
Oh, and by the way, he then stops the police. I just want to say this in light of what you said. He then stops the police. We shouldn't forget this. My client,
yeah.
he's driving with his father back to the neighborhood in general. He sees these cop cars. He then stops, and he says to the police, like, what are you doing here? And they say they're looking for someone of this description, and he then says to the police, well, I have red suspenders. Why would you say something like that? It's absurd.
Well, here's the thing, though. I mean, it seems to me that the trial lawyer, that the theory of the defense was that the witness, the victim, agitated, too quickly leapt to the conclusion that her attacker was this fellow that she had seen. So what I think the argument goes that the state should have focused on, the truth finder should have focused on, is what did the victim say immediately after the incident in describing the attacker. And she described the tan pants, the white shirt, the red suspenders, a beard, half-inch gauges, spiky strawberry blonde hair, and a funny gait as he ran after her, hunched over as if he were holding up his pants. That's a collection of items that are very random. I mean, wasn't the jury able to conclude that it was just highly impossible that there would be another man like that in the neighborhood?
Well, in general, in all honesty, it could be in a vacuum. However, this is my whole point. When you have somebody who's seen that same person repeatedly in the neighborhood, who thought he was creepy or something like that, and is in her mind, okay? And I don't know exactly when her boyfriend got back, by the way, and they had that conversation, but let's put that aside just for the moment, because I think he bolstered her.
Yeah.
But putting that aside, my recollection is she said he was like 5'9". They say closer to 6 feet, but my recollection is she said 5'9". And also the beard description does not match his closely cropped beard. So she is seeing him very quickly, as you said, very agitated, running out. And if you put that in a vacuum, you might say that's some evidence, certainly. But when you look at Remy de la Mora, who describes somebody with the same type of suspenders and everything else, and having a casual conversation with him, and he has no motive to be lying, he's also seeing the same identification of somebody that's not my client with the same kind of clothing. To say that somebody who wears red suspenders and tan pants and a white shirt, I have all that in my closet, frankly, and probably a lot of other people do. I think the key to this is, I think she transposed or transfixed, whatever the words are that an expert might use, what she'd seen previously of this individual that was walking in the street that she felt, and she transposed it onto this individual. But what she didn't say was there's tattoos. Now, I believe that the tattoos are critical because, again, if he's brandishing a weapon, like she says, and he has these tattoos on his fingers and his arm, it would seem to me that would be the first thing that would jump out as a description as well. She doesn't say that in the initial description, which leads to doubt. But then, again, when you combine the DNA evidence, and this is why I say,
Well, Counsel, you're making a very good argument to the jury that the evidence is insufficient, but it seems the standard is, at least from our point of view, is could a reasonable jury conclude that the defendant was the perpetrator and was guilty? Isn't the fact finder entitled to weigh all of the conflicting evidence and
well, there would never be a reversal under your standard. And what I'm saying is, no reasonable juror could possibly find in today's age to ignore the actual DNA evidence. If it was inconclusive evidence, that might be something you could argue. But where you have actual DNA of a third party, and you have a third party identified by another witness in that same time frame, wearing the same clothing, etc., who says this is not the person, and where you have the defendant stopping the police and admitting for no reason that he has red suspenders, why would you do that if you were guilty?
Counsel,
and then the timing, of course.
let me ask you this. I think with the exception of your thought that the victim's statements later may have been tainted, the jury had... the jury had all this evidence before it, right? I mean, this was not... In fact, I think they either heard argument about or evidence of confirmation bias. I mean, this was not a situation where the rules of evidence or otherwise excluded what you, with force, say was conflicting evidence. But you're not seeking a judgment of acquittal, right? There was no motion for a judgment of acquittal. It was a motion for a new trial.
Right. That's a fair statement. There was no request for that, so we filed an appeal on the new trial.
And Fisher, if this was a few years ago, the standard that the trial court was asked to apply, and the standard that we're asked to apply in looking at what the trial court did, would have been different. But Fisher takes a pretty narrow, one way to look at Fisher is it takes a pretty narrow review of certainly what this court should be doing when reviewing what a trial court did on a motion in a new trial, although it also talks, of course, about what the trial court should be doing or not. But help us better understand your argument under Fisher.
Sure. Well, look, the issue I think both parties identified is whether the court found there was substantial evidence. Contrary to what Judge Howe said, I'm not trying to re-argue right now a jury trial. I am saying that the court does need to look at the weight of the substantial evidence, and that's why I'm arguing that, because otherwise there'd never be a reversal of any jury verdict. Juries get it wrong many times. Juries ignore critical evidence that's dispositive. I don't think this court can simply just pass that off and say, well, they can do whatever they want to do. That's not also the standard. So what I'm advocating here, to be specific, is that where you have specific DNA evidence, no fingerprints, state's experts saying that he couldn't have been there at the time based on the review of the computer and cell records, it's contrary not only to the weight of the evidence, but it's not substantial evidence that any reasonable juror could ignore all of that evidence and simply say, we like the victim, we think she was a nice person, and therefore we're going to find against the guy and find him guilty and send him away for years in prison. That is not the standard either. So this court does have an obligation, in my judgment, to review that evidence and to determine whether it makes any sense and whether a jury verdict can stand in light of that evidence. And in light of the specific evidence that I've just described, I don't know how any reasonable juror could find this man guilty under the circumstances.
Let me ask you about, you mentioned the could not be there, the detectives.
Yeah.
That was based on the cell phone triangulation?
Yes.
Is that what you're referencing?
Yes, there was a call at 411, as I recall, and then they also determined that, yes, that it...
But didn't that evidence really come in as an approximation of where he was, as opposed to specifically, within plus or minus 18 inches, this is where he was? I mean, just cell phone triangulation.
Yeah, I mean, I'm not going to argue that point, Judge. I would highly doubt that they could actually pinpoint him exactly, but the point is, if you think about this logically again, and I don't think the jury did, think about it. He's waiting for his father to arrive. He gets out of his clothes, runs over there, knows somehow magically that this garage is going to be open. And what does he do? We don't even know what his purpose there was, because he didn't at least indicate, other than the knife issue that you can infer, to do anything. She immediately runs away, so we don't know what his intent was. But let's say you take it from the worst possible standpoint. Nothing really happened. That may be explainable. But it's not him. So that's the issue that I'm saying. The jury's saying, well, she ID'd him in light of the DNA evidence. To me, again, I repeat, and this is an interesting issue to me, but I think in light of scientific evidence as it's evolved, at some point, some of this ID stuff, which is inherently not all that reliable, how could it be reliable here when you have Remy De La Mora in the same time frame excluding him? How could eyewitness testimony form the final basis for a decision of guilt and putting a man away when there's no evidence that he's ever admitted this? In fact, evidence, as I said, to the contrary, where he said, I have read suspenders. Why would you say that? Why would you stop? Why would you talk to the police? It's incredible, incredible. And for a jury to just disregard all of that, yes, I do believe, Your Honor, that this court does have the responsibility to determine that this is not appropriate, that something went wrong, and that there was a distortion and a perversion of justice in this case, given the weight of all of the evidence. And if this court chooses to just ignore that and say, well, there was substantial evidence because the court said it's a he said, she said case. No, it's not a he said, she said case at all. At all. In fact, there's no he said at all here, other than the fact that we have DNA evidence that says it all. How do you ignore that and say it's a he said, she said case? That's my point. Otherwise, yeah, if you're just left with ID testimony, you have the distinction between the two IDs, which is questionable. But it's the DNA evidence that really sold me on this, because if you have specific evidence that's clear that it's not him, and you know his arm was hit in that doorway, and you have a third person that's not identified, but yet there's a person who is down the street shortly thereafter who's wearing the same clothing, etc., that is identified as not being him, and given all the other circumstances I said, the timing and everything else, I just don't understand how that's a substantial evidence to support the judge denying the motion for new trial. I do want to reserve some time, and I don't mean to short shrift it, but thank you.
Thank you.
Time flies here.
Ms. Francis.
May it please the court, Jillian Francis, Assistant Attorney General, representing the state of Arizona. The trial court does not abuse its discretion in denying a motion for new trial when substantial evidence supports the verdict. And just to clarify the standard of review, in ruling on a motion for new trial, a trial court can weigh the evidence and make credibility determinations. But this court can't do the same. This court has to defer to the discretion of the trial judge. And in this case, the trial judge found that the victim was credible. Because substantial evidence supports the verdicts, this court must affirm.
Can you talk about the DNA evidence part proves or doesn't prove?
Sure, Your Honor. The DNA evidence does not exonerate the defendant in any way. The testimony at trial was that DNA could possibly be left under the facts that the victim described, but that it was not certain. And just to clarify another point, it was a mixture of 3 people.
But the third person was not the defendant.
The third person was not the defendant. That's correct. But there, again, the testimony was that it's not guaranteed that DNA evidence would be left in that situation. And then just to pick up on a few other points, Remy de la Mora and the discussion about him, he did not testify at trial. The Sergeant Lockerbie told the jurors what Remy said. And Remy just provided the testimony from Sergeant Lockerbie was that Remy described a person with a similar description. And he did not say what items of clothing this individual was wearing. And he also was not excluded from the photo lineup. Remy did not make any identification.
Well, in other words, he was shown the same six-pack, and he said he didn't recognize any of the 6 as being the man who he chatted with that afternoon.
I'm not sure exactly what he said, but he did not.
He didn't pick out anybody.
Yeah, he didn't pick out anyone.
And defendant's picture was in the 6-pack.
Yes, he was shown the same 6-pack as the victim in this case.
But do you say that the person out there, or I just can't find the person?
He just was not able to make any specific identification or say, no, it was none of these people. He just had no response.
And that information was provided to the jury through the testimony of a detective.
Yes, that's correct. Also, just to pick up on the cell phone evidence, and that's in Exhibit 86, the court can see a map of the area that the defendant's cell phone was in at the times of the phone calls. And that area included the victim's home as well as the defendant's home. And any issue in regard to the photo lineup that the victim was shown and Mr. de la Mora was shown, any issue about that photo lineup being unduly suggestive or tainted, that issue was never raised in the trial court and was not raised on appeal. So that issue is waived. And also in regard to the victim's identification and her not stating that the attacker had tattoos and incorrectly identifying his height, this victim viewed her attacker for about 3 minutes. She provided a very detailed description of her attacker. She was under the stress of the situation. Her description matched the defendant. It was corroborated by the results of the search warrant at the defendant's home, which revealed the folding knife, the red suspenders, and the tan shorts. It was corroborated by Exhibit 82, which is an image of Reyna wearing the red suspenders that was found on his home computer. And this image was taken before the attack. It was corroborated by Peter's testimony about the individual they had seen in the neighborhood before. And in the photo lineup, the victim confidently identified her attacker. So in light of all this, the fact that she did not correctly estimate his height and did not notice his tattoos at the time of the attack does not make her overall identification unreliable.
Does the record show that she was asked about tattoos and said she didn't see any, or that she simply didn't mention tattoos?
At the time of the 911 call and her reports to responding officers, she didn't make any mention of tattoos, and I didn't see anything showing that she was asked
I didn't see
specifically.
that she was asked either, which would tend to confirm that she leapt to the conclusion that it must have been the guy that she'd seen on the street, because when she saw the guy in the street, she was too far away to see his hand tattoos.
Yes.
But your point is that's a jury argument.
Yes, and she also said in the 911 call, I believe you can hear her saying, it's a guy that I've seen him before in the neighborhood.
So she had already, there are two ways of viewing that, right? The the briefs make the point that that confirms the validity of her identification. On the other hand, it undermines the validity of her investigation if you think that what she was talking about was the man she saw on the street, not the man she saw in the house.
You could interpret it that way, but I think it strengthens her identification because the testimony about the neighborhood they lived in was that it was mostly older people that lived there, and it was kind of rare to see younger people there, and this is someone they'd seen multiple times before. If this court has no further questions, the state asks that you affirm the decision of the trial court.
Thank you. Mr. Willingham.
Let me just hit a couple of quick points here, if I may, that were asked. Reyna de la Mora, my recollection, I was just trying to find the appendix reference. I believe it's at page 82, but I just couldn't put my finger on it. Reyna de la Mora, our brief notes, spoke to a person with a similar description, and it was not appellant, wearing red suspenders and a white shirt about 15 minutes prior to the police arriving on the scene and the victim calling 911. The state reported that Mr. de la Mora could not identify the person as Reyna. De la Mora was adamant that he could identify the person he met. However, he did not see that person in the lineup. So I don't want to, split hairs, but I think that's important, that it's a matter of how we couch things. Clearly, he believed he knew who that person was within 15 minutes of the incident. It did match the description of what the victim said, but it was not Mr. Addison Reyna. So again, if you couple that with the other DNA evidence and so forth, and again, I don't mean to quibble, but the state's, way of saying things is just different than my way of saying things. There was DNA evidence found in the very spot of a third person, in the very spot where she described it would have been. And it wasn't him. That is, to me, substantial. And the court doesn't even reference that if you read the transcript of what he says. He just says eyewitness ID is fine, okay? That's the end of it. It's not the end of it. Substantial evidence and a determination, and I'm not asking this court to weigh credibility. I'm saying let's assume she said she saw what she saw. I believe that the evidence was tainted by the way and manner in which she was shown that six-pack. He was the only guy that would have matched any description at all.
That wasn't raised, correct?
What was not raised?
That the ID was tainted.
Well, yeah, no, it was raised in the discussions, I believe. Are you asking, was there a separate hearing on it?
Yeah.
I'm not aware of that. Yeah. That's.
And to close that loop, it's not part of your argument here.
Well, it is part of my argument because, as I said,
Are you challenging, I don't read your briefs as challenging the court's ruling that the victim could testify?
No,
okay.
Absolutely.
That I just wondering.
It's a substantial evidence issue that this court needs to independently weigh de novo. Thank you.
Thank you, counsel. We appreciate your briefing. We appreciate your presentation today. We will take the matter under advisement. We'll issue a written ruling in due course. Thank you. We stand adjourned.